Everyone. Hello, hello, hello. Hi, everyone. This is Ifeoma Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. I have a great topic for you guys today, and it's I'm going to use a one of my success stories. I have so many, but today I'm really excited to talk about this story because this client of mine, has been looking for a green card. He has been in the process of getting a green card since 2009 with other lawyers, not me. So that is going to be the basis of my life today. I want to talk about waivers. I want to talk about his journey, what the other attorneys did that wasn't helpful, and how we were able to get him his waiver approved. So when you join in, please make a comment. Let me know where you're calling from, and I will get started shortly. So, for those who do not know me, my name is Ifeoma Odunlami. I am an immigration attorney from the Odunlami Law Firm in New Jersey. My law firm serves clients from all 50 states. So it doesn't matter where you live, immigration law is federal law, so I'm licensed to practice in 50 states. So I'm really excited because I have a new setup today. You may not notice it, but it's easier for me to face people on Instagram as opposed to you guys getting just the side of my face. So join me. Let's get started. So guys, whenever we get something, like, there are many stories and there are many successes, but there's some stories that when the client comes to you because they've had such, I guess, bad luck with whatever they filed in the past and it hasn't worked, and they tell you, you are my last hope. And that's such a heavy, heavy, heavy burden, because when somebody says, you are my last hope, they don't have anywhere else to go. So this guy, and for the sake of, you know, uh, privacy, I'm not going to get into a lot of the details, and, I might just skip some details that may identify who he is for those that know him. He came to us a year ago. I think it was during COVID, and he said that he had gone through the process. And I'm going to tell you, because I have his previous filings here. He started the process in 2009. He was married to a U.S. citizen in 2000, and filed the petition, the I-130 and the I-485, in 2009. And then his I-130 was approved I think it was approved in 2010, right? But the I-485 was denied. So for those of you that don't know the difference, I'm just going to discuss it really briefly. The form I-130 is typically the form that the U.S. citizen files on behalf of the intending immigrant. Now, the I-485 is the adjustment of status. With the I-485, you file the I-765, which is a work permit that allows you to work while you're waiting for your case to be processed. You also file the I-131, which is the which is the travel permit that allows you to leave the country and come back again while your case is still being processed. So it says here that he filed in May 9th, 2009, and the I-130 was approved, but the I-485 was denied. And the I-485 was denied because of inadmissibility issues. He wasn't admissible. He had some issues based on prior criminal convictions. That made him inadmissible. Those are the terms that we typically use. That made him inadmissible, so he could not adjust his status. So his attorney then, I think he had about maybe 2 or 3 violations. So they're not heavy crimes. They're called crimes involving moral turpitude because they involved theft. I think it was all in municipal court. So he had a lawyer then who applied for him for a waiver, and USCIS denied that waiver in 2016. They denied the I-601 application to forgive the criminal background, right? The crimes involving moral turpitude. So his lawyer then appealed and went to the Administrative Appeals Office. And that appeal was dismissed in 2017. Then in 2017 again, his lawyer filed a motion requesting to reconsider or reopen that decision. In 2018, the Administrative Appeals Office denied that motion. So this man was pretty much out of luck, and he had gone as high as he could go. So he came to my office and said, "What do I do? I have tried everything I can do, and there's nothing, there's no way forward." He needs to be able to work so he can support his family, and he can't do that. So the first thing we did was we asked him to bring the documents he had on him that his lawyer gave him. We also did a FOIA, a Freedom of Information Act, a USCIS FOIA, to get all the records that USCIS had on him. So when we reviewed those documents, it was clear to us that the 601 waiver was not very compelling. So when you file a waiver, you have to prove hardship, extreme hardship on the US citizen, either a spouse or a parent. In his case, it was a spouse. So you have to prove that that person is going to suffer extreme hardship if you were not allowed to stay in the United States, and it would not be feasible for them to follow you to your country. So there are many things that we look at, but the good news is we got all the information. We did the psychological evaluation of the US citizen. We were able to, we interviewed him. We got all the information that we needed from him, from his wife, and we were able to get a very strong package with a brief citing case law showing that his wife would suffer extreme hardship if he was not granted this, if he was not allowed to adjust his status and stay in the United States. And I think it was a few weeks ago, the I-601 was approved. Guys, this is a journey from 2009. This is 2022. And I think he had gone through, I'm not sure if it's one attorney or a couple of attorneys, right? But when he came to us, we noticed that the issue was a 601 that was not prepared vigorously. Because when you have to prepare these applications to show extreme hardship, you really have to dig in and get the information you need from your client. You really have to dig in with the case law and prepare a powerful brief. So that happened. And so now he's going to be able to adjust his status. As a matter of fact, we just got a request for evidence for his medicals. And when you get a request for evidence for your medicals, typically it means that USCIS may not even interview you. They're probably just going to send the green card in the mail. That has been our experience with a lot of clients. So today I want to talk about waivers, because that's what we did for this man to get him in a position where he can apply for his adjustment of status and get a green card. We applied for a waiver to forgive his criminal background. So let's talk of different grounds of inadmissibilities, right? And you guys should probably listen to this, because a lot of times people come to my office and they have done things that make them inadmissible, and they're not aware of it because maybe everyone is doing it, or maybe nobody ever told them, or nobody ever asked them the proper questions. So let's talk about different types of inadmissibilities. The ones we see a lot is misrepresentation or fraud. Misrepresentation or fraud is when you falsify or misrepresent key information, either to get a visa, or you commit a fraud during the visa application by not giving the officer the truth, or by presenting false documents. So I want to talk about this in particular, because this is something you guys need to hear. What are the examples of misrepresentations or fraud that can get you in trouble, that will make you require a fraud waiver if you want to go forward with an application process? the first step is for those who are applying for a visa coming from their country. Your first contact with USCIS is when you go to apply for that visa. Let's say it's a B1, B2 visa that you apply for. I've known and I've heard of clients or potential clients who go to the office and lie about their marital status. They say they're married because they believe that it will make it more likely for them to get a visa to come into the country. Now, what happens is they come into the United States, they fall in love with somebody, and they get married. And when you get married, USCIS wants to know how many times you've been married. So there are two scenarios here. Either the person says, I've never been married before, and then USCIS at the interview says, well, at the visa interview when you were looking for a B1, B2 visa, you had said that you were married. So what is it? Are you married or aren't you? That is a misrepresentation, and that's fraud, actually, because that's a lie. So that in that case, you would need a waiver. Or they get a fake divorce decree, right? Or a fake death certificate. And that is misrepresentation. And if USCIS catches on, and they typically will, so honestly, you guys, I have to tell you, don't do it, because they will find out. This is 2022, not 2009, when the world was not connected. You know, there were no ways to verify certain information. For instance, in Nigeria, you get a fake divorce decree from Lagos State Judiciary. Are you aware that your decrees are online? USCIS just needs to put in the docket number you gave them, and if it's not there, then it's a fake divorce, and you will be denied for that. So if you have a fake divorce decree, a fake birth certificate, a fake death certificate of a spouse, or you claim that you have a child, or you claim that you're married and you're not, those misrepresentations and fraud will require a fraud waiver. And for you to get a fraud waiver approved, the qualifying relative has to be a U.S. citizen or green card parent, a U.S. citizen or green card spouse. Your child, your U.S. citizen child, cannot be a qualifying relative. So I hope you guys understand this, because I have a lot of clients who come to the United States, and they have kids here. The children are now 21. They came in through the border, which itself requires a waiver because you were not admitted and you were not inspected. So once the child turns 21, they know that a U.S. citizen child who's 21 and above can file for their parent. But unfortunately, if you come in through the border without inspection or without admission, you must get a waiver. And if you get that waiver, which is called a provisional waiver, then you can leave the country and go to your embassy and get a visa to come in. However, the problem is your child cannot be a qualifying relative. So if you have another relative, like your parent who's a U.S. citizen, even if your child files for you, you can use that family member as a qualifying relative for purposes of filing a fraud waiver. So let's talk about other ways of misrepresentations and fraud that have made it difficult or created a stumbling block for intending immigrants. Another one is those who come here with a student visa and never attend school. So you apply to go get a student visa, and then you come in here and you don't go to school. That's misrepresentation, and USCIS actually would see that as fraud. And even if you marry a US citizen, they may require you to file a fraud waiver. Now, another ground of inadmissibility is health. Believe it or not, your health status may make you inadmissible. So, for instance, if you have drug issues, that could make you inadmissible. If you have a diagnosis of a communicable disease, that can make you inadmissible. Or you fail to get some required immunizations, that can make you inadmissible. Or you have a dangerous physical or mental disorder. These are just examples. Now, another inadmissibility is unlawful presence. If you're in the United States without legal authorization, right? Like I talked about, people who enter without inspection, typically they will need a waiver if they're looking to get a green card. They cannot adjust their status. Now, there are other people who, like, if you have a sibling who files for you and you're in the country, remember, for a sibling, it takes a long time before their priority date is reached. So if your sibling is in the United States and they have overstayed their visa, they cannot adjust their status because they're not in a preference category. So they would have to also file a waiver. And like I said, a qualifying relative for a waiver can only be a spouse who's a US citizen or green card holder, or a parent who's a citizen or green card holder. So even though you can file for your sibling, if you have a parent or their spouse who's a citizen or green card holder, they can use that person as a qualifying relative, or, you know, or they can actually have, maybe they can have the parent file. But a lot of times when you're looking for somebody to file for you, you're looking at which is the quickest way for you to get your priority date. What's the quickest priority date? The good news to know is this. A lot of this circumstances that I've talked about can be forgiven by way of a waiver. So either, whether it's your health or, criminal background, or misrepresentation or fraud or unlawful presence, it can be forgiven if you meet all the other qualifications. So if you or anyone you know is in a position where you are going to need a waiver to be able to adjust your status or to be able to get an immigrant visa, you should call my office, 973-993-1900. And as a matter of fact, there are also waivers for people who are even looking to come in here with a temporary visa. So that's really it. Does anybody have any questions? This is a really quick one because it's about 5 o'clock. I just wanted to come in here because I was really excited for my client. And since 2009, he's been in the immigration process, filing, being denied over and over again, appealing, being denied, until he came to us and we were able to put the paperwork together and we were able to get his 601 waiver approved. And so now he's on his way to getting his green card, God willing. So guys, that's all for today. Thank you for joining me. Again, my name is Ifeoma Odunlami, immigration attorney from the Odunlami Law Firm, also a proud immigrant. Take care.